Morning. This is Warren Shiel, and I have today with me two outstanding forensic accountants, Avi Reichman and JB Rizzo. So thank you very much, guys, for coming here. Do you briefly just want to introduce yourselves and what you do?
Sure. Thank you, Warren, for having me on. My name is JB Rizzo. Our firm is Frankel, Reichman, and Rizzo, and I am a forensic accountant for family law in litigation support and mediation support. I'll let Avi introduce himself.
Good morning. I'm Avi Reichman, one of the partners here at Frankel, Reichman, and Rizzo. Our firm, as JB alluded to, specializes in forensic accounting with a heavy concentration in family law. We get involved in matters involving the calculation of income available for support, valuation of closely held businesses, tracing of separate property, preparation of community property and separate property balance sheets. And anytime parties going through a divorce have questions about the numbers, we're the firm they call.
Yeah, and I can second that. I work with both of you. How you guys doing? So, Avi, you've got the COVID beard, which is new.
I do.
Right? And you look, and that looks like a virtual background.
That's correct. It's not actually nighttime where I am.
That's right. Whereas JB, you look like you're in the office right now.
Yes, I'm in my office, and Avi's actually in the office next door.
Oh, really? Okay. How's a COVID affecting family law and your business?
So I think initially I anticipated it would have a much greater impact than what I've actually seen. JB and I are both very settlement mediation oriented. So while we go to court and we've both testified numerous times, our preference is to try and resolve matters outside of court. And that work has continued even through COVID. We're seeing settlement conferences done via Zoom. We're seeing analysis done. And even though we're not meeting in person, we're sharing information electronically, and things have continued to really move forward.
How are those Zoom meetings and mediations and conferences worked? I mean, has everyone adapted to that technology, do you think, including the conference judges and mediators?
So my experience is the more everyone gets used to it, the less hiccups we're seeing. There was certainly, at least initially, some technological hiccups. Sometimes a judge will put you in a breakout room and put you in the wrong breakout room, and then try and figure out how to get you back in. I found also initially that the process took a little bit longer than being in person, but as we get used to living the new normal, things are moving along pretty smoothly.
Let's back up a bit and talk a bit about, like, because this is going out to, I think, a general population, lay people. So tell me a bit about what a forensic accountant is and what you do.
I think in simplest terms, most people can understand when they're going through a divorce that they're going to be entitled to 50%. And it's like, percent of what? And that is, of course, we know alludes to the community property and the assets and also shared liabilities. But for the layperson, I say we help figure out the 50% of what on the property division side. And then on the support side, we figure out how much someone actually makes. We as professionals know that tax returns are prepared to minimize taxable income reported to the government. And in the family law world, that is also well known, but the family law in California takes the position that you pay support on income available for support, which is a technical term that does not equal taxable income. So how much does somebody really make? That's what a forensic accountant can help you do, meaning the lawyer, and helps the lawyer assist the client in determining what support should be paid.
Now, your role can be different depending on the assignment. You can either represent one of the spouses or one of the parties, or you can be what we call a joint forensic. Can you explain the difference?
Yeah, in a joint role, there are several jargon terms for that. 730 or court neutral expert, but they all mean the same thing. And the role of the forensic then is to look at the issue from both sides of each party's legal positions and either come to one answer, or many times when I'm a joint, I will run different scenarios from the point of view of client A and the point of view of client B, if there are different legal positions that each party can take. That is a different role than if I'm on one side or the other, in that in those situations, we would take the legal position directed by the attorney whose team that we are on.
Well, in an ideal world, if two people want to get divorced and they come to you and they're looking for the best optimal outcome, you know, is it better to retain separate forensics, or would you have a joint forensic? How is the best way to move forward, and particularly now that we have COVID with all these different types of restrictions? What's the best way to move forward with a divorce where there's complicated cash flow issues and maybe valuation of businesses and the like? What would you advise?
So I think, if I can jump in, I think it really depends on the parties. I think JB and I have both had cases over the years where they'll come in and say, we agree on everything, everything's amicable, we just need someone to run the numbers. And sometimes very quickly from talking to the parties, you realize there's simply a lack of trust over there. To a certain extent in our role, we're looking to substantiate the numbers and we're looking to obtain documentation. But for certain things, you're stuck relying on the party's representation. An example could be meals and entertainment. We can get every receipt in the world for every meal that was charged to the business, but at the end of the day, we're relying on the parties to tell us who they had that meal with and what the business relationship was with that individual. And even if we go to the next step of verifying who the lunch was with by looking at a calendar, we're still relying on the party's word to tell us what the business relationship is with that individual. So I think in our work, we're advocates for our opinion. We're not advocates for our client. We should be coming to the same results irrespective of which side we represent. And it's just a question of, are the parties going to be able to agree on certain basic assumptions, in which case a neutral makes a lot of sense, or is everybody going to tooth and nail to make sure that their best foot is put forward? And in that case, I would say the parties probably need to get two separate forensic accountants.
That was a really brilliant answer, Harvey. Thanks.
Thank you.
I think that so on the one hand, you mentioned looking at the facts, but then there seems to be an element of subjectivity, at least when it comes to forming an opinion. And you've given the example of what we call perquisites and analyzing cash flow. Just for people who don't understand that, when we're calculating cash flow or income available for support for the purposes of either child support or spousal support, we usually start with the tax returns, right? And sometimes there are deductions in the tax returns, such as depreciation on property or equipment. And in family law, then we sometimes add back perquisites, which really should be part of the cash flow. And so that's where the subjectivity comes in. Is that what you're saying?
That would be one example. There could be subjectivity in determining perquisites. There also could be different legal theories to follow. An example can be, if we're valuing a business, what the date of separation is. or what the date of value is, whether it's evaluation as of the trial date or the date of separation. We can prepare a valuation based on either date, but it would be up to the attorney to advise us as to what date to use. And if there were two forensic accountants, they could be looking at two different dates potentially, versus in a neutral role, that would be something that would need to be agreed upon.
I mean, it seems that accountants, you bring accountants in to look at the facts, to look at the numbers, and they say they run the numbers. But rarely do accountants seem to agree, at least in the beginning, until they narrow those disagreements down. In the context of a business valuation, why do accountants disagree by such huge numbers?
In the business valuation space, a large determiner of the business's value is an assessment of the business's risk. So two reasonable experts could disagree on the impact or the significance of different risk factors, and that could cause them to differ on value given the same set of numbers. That's one area of subjectivity that I do see.
I mean, when we had a conversation about this, I think a few weeks ago, JB, you made a very good point, which was that not all businesses, particularly small, closely held businesses, need to be valued. Can you explain that?
Yeah, you know, the first decision tree on whether you're going to do a business valuation is to analyze a business to see if they're really making more money than what they would be making doing a similar job. Looking at the gross receipts, in that, is it enough to support what reasonable compensation would be for someone performing the same services to that business, for that business. So there, you know, just because you report your income to the government via a corporation or via a Schedule C does not always mean that you have a business that is significantly of value. And when I refer to a business of value, I'm really referring to the intangible assets or the goodwill of the company. Obviously, every business that has a bank account, okay, the bank account is going to get, you know, has some value. I'm really talking about the intangible pieces that give operating businesses value in excess of how much money's in the bank account or how much money it's owed by vendors, et cetera.
So when someone's looking to buy business, they're not just looking at the asset value, how much is the bank, what the value of the lease is, what the value of the equipment is. There's an intangible asset called goodwill. And that's what they're paying for when they're buying the business. I'm just kind of curious, in your years of practice, what's the biggest divergence in values of a business that you've encountered, where you've come in and said the business is worth 5 million and the other person, the other accountant on the other side said it's not worth anything, so it's zero? Have you come across those kind of huge differences in your practice?
And I had one recently that went to trial, and I think it was somewhere close to a 10-to-1 ratio, where a business was worth either close to 6 million or 600,000. And both experts really agreed on the input. The question there was what date to value the business. The business in that case had seen huge growth after the date of separation, and fundamentally it came down to a legal argument as to what date to value the business as of.
Was there a motion for a separate valuation date?
There was.
Well, what kind of
ultimately that motion was granted
to value it at the date of separation?
To value it at the date of separation. So my client was hoping for the later valuation date and was not overly thrilled with that result.
And what was I'm just curious, what was the reasoning that the judge used in justifying
the reasoning that the judge used was that the business was heavily driven by the spouse operating that business, and the value created by a spouse's effort after date of separation are the separate property of that spouse in California. And based on that, the judge felt it appropriate to value it as of date of separation. And any increase in value would be the property of the separate spouse's effort post-separation.
And that's quite a common disagreement, isn't it? When you have smaller businesses which are primarily operated by one spouse. Let's go to cash flow, because that's another big area where you do a lot of work. I see a new case came down called, I think it's Hein versus Hein, just yesterday, about depreciating on equipment. What are the why would I hire you to do a cash flow analysis for support? What's the reason?
I think probably the simplest answer would be you would hire me to do a cash flow because the numbers you were given do not appear reasonable. If everything running through the business was a business expense, if there was no personal component to it, you could take a number from the tax return and peg that as husband's or wife's income. If you're looking at it and based on conversations with your client or based on your experience looking at the numbers, something doesn't seem right to you. Maybe they live in a $5 million home and they're reporting $50,000 a year of taxable income, and there seems to be a discrepancy. You would want the forensic accountant to look at the tax return, look at the underlying documents, and give you a report and an opinion as to what the true cash flow is.
What are the kind of problems you encounter with doing that kind of cash flow analysis?
Sometimes there's unreported income. Sometimes a business could have a lot of cash that may be off the books. Sometimes you'll have a business that's in one person's name, but another party is the beneficial owner and is receiving all the cash flow from it. But the most common adjustment we make is for what you alluded to earlier, is for perquisites, which is personal expenses being run through the business. And that could be car expenses, that could be meals, that could be pension, that could be life insurance, that could be groceries. It really runs the gamut.
One of the things that we've encountered during this COVID pandemic is that people's incomes are uncertain. They're fluctuating. People are losing jobs. Some people are getting grants or PPE grants. You know, both the recipients of support and the people paying support, their income's uncertain. How have you been dealing with that in your cases? What's the approach? Is there a general approach you take with that?
So I can speak to what I do. Everyone does it a little bit differently. I'm always a fan of reporting what's known first and then trying to adjust for it. So my preference would be, let's get a baseline. Let's look at what that party's income is for 2019. And then let's talk about the factors that are causing it to decrease in 2020. And then let the court make a decision. In my mind, to look at a period, and at this point, we've been in this pandemic for a few months now, but there were people going to court at the end of April saying, look at my income for the last month. I have no income. I don't find 1 month to be a representative period. But on the flip side, it's probably not going to look like 2019 either.
Yeah.
Yeah, I think, you know, with respect to the COVID, you know, courts don't make decisions on predicted income. Like Avi and I, we calculate actual income versus with actual records. So you kind of in this catch-22 where, okay, you expect your income to go down, but how can you ask the court to make a decision based on what you predicted to go down without showing any actual evidence of what is happening in the business? So that's something that I would add. Another thing I would add is, you know, did one or both parties, did the lifestyles change? Like, how are they paying for their expenses during this time?
Mm-hmm.
That might be a factor that the court might want to look at, is how are they actually living? Did they actually have to go out and borrow a whole bunch of money to make certain lifestyles? Did somebody not being able to pay rent or this or that? if any of those factors exist, I think that would be something good to tell the court.
I think Avi made a very good point, and you make a point that when we're looking at income, and we're generally looking at a representative sample of income from the past. The family code says presumptively it's 12 months, but sometimes we go back further. Another thing the courts often do is if income fluctuates, for example, typical example would be commissions or bonuses. The court will often establish a baseline, and then over and above that baseline, we do what's called an Osler-Smith calculation. And periodically, it could be every quarter, it could be once a year, it could be more frequently. If your income is over and above that baseline, then you pay a percentage of that in support. Have you been seeing a lot of those Osler-Smith orders or agreements as a result of COVID?
I'm definitely seeing it more for exactly the reason that you're saying. The court doesn't want to base support on a number that's not representative, but the court also wants to be cautious in looking at the facts as they exist today and realistically saying that 2020 probably won't look like 2019. And so what I'm seeing is the courts or the mediators are trying to find a reasonable baseline so that the base support is too high, but if the income is higher, the supported spouse still receives support on the full amount of income.
One of the things that, I don't know if this has come up in your practice, but right now a lot of people are relying upon care loans and small business loans and salary replacement loans. And in some cases, we don't know yet whether those are income and loans, because I'm not sure the rules have actually been written on if they're going to be written off. Have you encountered those kind of problems? Because generally loans are not considered income. Any one of you had that kind of issue come up yet?
We've had it, I would say at best it's non-recurring income. But I think also the presumption is you look at the facts as they are right now, and as we sit here today, it's a loan. It may be forgiven, but I don't think the banks are even processing those forgiveness applications as of the current date.
The other big area why we should hire forensics, just to keep them in full employment, as divorce lawyers as well. We talk about the Divorce Lawyer and Divorce Forensic Accountant Full Employment Act, in recognition of the fact that divorces are quite high in Los Angeles County, California, generally. But the other area where we retain forensics is with tracing, where funds are commingled. Can either one of you speak to that and what it means? What is a tracing?
Well, a tracing is done to prove separate property. Separate property of one spouse or the other is assets that they had at the date of marriage, or assets that they received via inheritance or a gift, and the profits and rents, et cetera, that derive from those assets. So when folks have a commingled account, it is on we call them the separatizer, is the person that would claim the separate property, has to prove to the court that the separate property exists. It has to be traced to a separate property source. And tracing means that myself or Avi or others would present the court evidence of where dollars went. Did it go through bank accounts? Did it go through investment accounts? Did it go through real estate? What happened to the separate property from the point of receipt till whatever is known?
I mean, I think we talked about this before, JB, and I consulted with you recently, Avi, on a case. It was to do with where someone brings into marriage a piece of real property, like a residence, and it's titled in that person's name, and they don't have a prenuptial agreement, and during the marriage they pay down the mortgage from community funds, or they refinance. and the community acquires what we call a more Marsden interest, which can be very substantial. Can either one of you sort of elaborate on a more Marsden interest and how the community can acquire an interest in separate property? Don't jump in at the same time, guys.
I think when it comes to community and separate property, it's not an all or nothing. So one spouse may have brought a piece of real property into the marriage, but to the extent that the community supported that property, either by paying down the mortgage or by assuming the loan or by paying for improvements, they would get a proportionate interest in that property. So while the property may retain its character as separate property, a calculation would need to be done to figure out what the community's interest would be based on the amounts that the community put towards that asset.
I think a lot of people, lay people, don't understand that. They assume, well, if the title is in my name, then it's my property. And they don't realize that the community can acquire an interest in the property. I just briefly want to touch on two other things which also surprise lay people when they get divorced. And that is Watts charges and Epstein credits. In 60 seconds, can you describe what an Epstein credit is and a Watts charge?
So a Watts charge is when one party retains a community asset, they would owe the community back for the use of that asset. In the simplest form, it could be one party living in the former family residence. That residence could theoretically be rented out, generating rental income. So the spouse using that property would owe a Watts charge back to the community. Now, these are discretionary, and it's up to the court's discretion as to whether or not to grant a Watts charge. An Epstein credit is similar, where you have one party paying for a community expense. Most commonly, it would be mortgage or property tax on a residence. Since they paid that expense on behalf of the community, they would be due back reimbursement from the community. And since each spouse is one half of the community, they would be due effectively from the other spouse 50 cents on the dollar.
Excellent. Thanks.
And
I just want to, you know.
I just want to add, you know, for the lay person, they gotta, first thing to understand is when they get married, it's not his and hers anymore. There is this community that we're all three of us have been talking about that gets created. And think of it as like it's another entity in and of itself. And therefore the courts and the law thinks of things in terms of the community versus separate property. And I think that's sometimes hard for lay persons to understand that it's not just his and hers. Another, I think, concept that at least I come across with lay persons and going through divorce is that, you know, at the date of marriage and during the community gets created, and now their earnings from their job or from perhaps the business, their earnings are also community property, no longer his or hers. So those two key concepts, if clients, the quicker that they can grasp that, I think it's easier for them to understand and to navigate the divorce process when talking to us, when talking to you, Warren. Like, they can get the concepts easier if they can break the mindset of his and hers. But that's very difficult for clients to do because they're in emotional trauma going through the divorce. But that is what I would advise for lay persons.
That's so true. I mean, at the most basic level, some people even assume that a bank account or a credit card, simply because it's in one person's name, must be their responsibility or their asset. Whereas in fact, if it was acquired during the marriage, it's a community asset or a community liability. And that is the important thing, because in California, in the absence of a prenuptial agreement, and of course, a prenuptial agreement changes everything. But in the absence of a prenuptial agreement, there is a presumption that anything acquired or any debts incurred during the marriage are community, because we go back, 100 years to being a community state. And if you want to prove that there's a separate property interest, I think, and this is one of the things the Court of Appeal recently, and we're talking at quite a high level now, in this recent case that came out, there's two, Rodriguez and Hines. They talk about the burdens of proof and the burdens of production. So more often than not, it's the person claiming the separate property has the burden of proof on that. Before we go, really didn't get an opportunity to talk a bit about your resumes, because I know both of you guys got a lot of letters after your names, and you have a lot of experience as forensic accountants, both with your own firm and working in other firms. I'm just going to introduce myself. My name is Warren Shiel. I'm a divorce and family attorney. I was licensed in the UK. I practiced in New York as an attorney, and I've been here for the last 16 years. So I've been practicing for nearly 30 years. I'm a certified family law specialist, and I do exclusively divorce and family law. I'm just going to give a shout out. My telephone number, my office number is 310-247-9913. We have a website, www.la-familylaw.com. Over to you guys. What's your resume and experience? And what do those letters mean after your names? You want to go first, JB?
Sure. Our firm, Franco, Reichman and Rizzo. Our website is www.calcpaexpert.com. CALCPAEXPERT.com. I'm a CPA in California and Nevada. The other initials I have just are business valuation credentials and financial forensics.
We'll edit that one out. Yeah, sure.
Blah, 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 blah. The real one that only matters is the CPA. The other stuff is good, but the layperson probably wouldn't understand that much either about it. It has to deal with business valuations. The point is that I've been doing this family law. I don't do taxes. I don't do accounting. I've done only family law since 1999. And before that, for a few years, I was doing money laundering and fraud investigations for a large accounting firm. But, family law and business valuation.
Can I stop you there for a second? You were investigating money laundering.
Yes.
I was going to ask, you were, yeah.
Did I say that? Great. Yeah.
Yeah, you weren't money laundering.
Money laundering, and I was not.
Okay, we'll make that absolutely clear on this podcast.
We're going to be calling our malpractice carrier after this call.
Yeah, it's my first time on TV, so I'm not an actor. This is so. Yes, I did not. I investigated those crimes for our clients. So the point I wanted to make was that family law is what I've chosen to do. I hope that clients out there can mediate their cases and settle things, but if they cannot, the courts will make the decisions for you. And we both Avi and I, we care about our clients and we care about our cases, and we do the best that we possibly can to help folks resolve their issues. And I'll let Avi introduce himself.
Thank you very much, JB. Thanks.
So similar to JB, I'm a licensed CPA. I'm also certified in financial forensics and accredited in business valuation. What that means is we can run the gamut of a family law case. There are a lot of experts out there, for example, that don't do business valuations. We'll do the business valuation. We'll do the tracing. Both JB and I have testified in California courts numerous times, but really our preference is to get a case to settle. And the way we do that is, I think, Warren, you alluded to earlier that sometimes experts can disagree and the agreement can be large. Our goal is really to narrow down the difference. And the example I talked about earlier, maybe the difference is just what date of valuation you use, but maybe the two experts can agree that if it's valued as of 2017, it's this value, and if it's valued as of 2019, it's that value. And that's something that the judges and the mediators really appreciate because it allows them to really make an informed decision. Another thing that makes us a little bit different than a lot of other forensic accountants is myself, about 25% of my practice is tax work. So I find that, the tax work helps me understand a tax return that I look at in the context of a family law matter. Usually tax returns, even though they're not always 100% correct, they provide a starting point. And on the tax side, I tell people that even though I may not do as many returns as a traditional tax preparer, I see a lot of returns prepared by others. So probably by the second or third time, I should be getting it right, even though I may not know what I'm doing the first time around. But no, we do practice a certain amount of diligence in everything we do, and nothing goes out of the office unless it's reviewed by a partner. JB and I will bounce ideas off of each other, and our reputation is what we sell, and that's not something we're willing to compromise for anything. And
do you do any money laundering?
No
money laundering.
Do money laundering. We would investigate it, but we do not do money laundering.
A couple of years ago, you won an award. Can you just tell us about that?
Yeah, so I've been nominated by the AICPA. Despite the beard, I'm a little bit younger than I look right now. So I was nominated as ovation recipient for the 40 Under 40 award. I received a similar award from the NACFA, the National Association of Certified Valuation Analysts. And most recently, it hasn't been published yet, but it should be coming out Friday. I am going to receive the California Society of CPAs Volunteer of the Year Award. Try and give back from the professional knowledge we have and give back to the community wherever we can. And I feel honored to be receiving that award this Friday.
Oh, congratulations. That's very impressive.
Congratulations.
I really appreciate speaking to both of you and you giving us your time. And I love working with you guys. So thank you very much. And I'm going to press the stop recording button now.
Thank you, Warren.